Members, it's the appointed time. We have a quorum. I call to order the meeting of the panel on the administration of justice and legal services. Item 1. Since the meeting on the 28th of April 2025, no information paper has been issued by the Secretariat. Now, next items for discussion at the next meeting. Now, for the regular meeting in July, we will hold our next such meeting on Monday, the 7th of July at 4:30 p.m. At that meeting, this panel will discuss reviewing and enhancing the on-the-job training of legal practitioners. I have also instructed the Secretariat to discuss with the government and the judiciary administration the other proposed item for discussion. Once we got a recommendation from those parties, I will instruct the Secretariat to let members know what we would do about the other item for discussion. Now I turn to the regular meeting for September this year. So we were going to hold a meeting on the 8th of September, 4:30 p.m. Instead, we will move that meeting to the 9th of September from 2:30 p.m. to 4:30 p.m. Any comment? No objection? All good. We move on to the next item, the pilot scheme on community mediation and review of the mediation regulatory regime. Members who would like to speak, please press the request to speak button now. I now invite the Secretary for Justice and his team to join us. Welcome, Mr. Paul Lam. There are 3 papers for this item. 1, CB bracket 2, 1027/2025 bracket 03. That's the paper from the Department of Justice on this pilot scheme. The second paper is number CB bracket 2, 1027/2025 bracket 04. Also from the DOJ. This paper is on the review of the mediation regulatory regime. The third paper is from CB bracket 2, 1027/2025 bracket 05. This is a background brief prepared by the Legislative Secretariat. Now first I give the floor to Mr. Paul Lam, the Secretary, who will walk us through the paper. Thank you, Chairman. Good afternoon, members. I'm pleased to be here to brief members on 2 efforts of the DOJ on deepening the culture of mediation. First, we have the pilot scheme on community mediation. The second item is the review of the mediation regulatory regime. I want to give members an update. First, the pilot scheme. The 2024 policy address sets out efforts to promote mediation culture. We want to encourage the public to use mediation, which is an efficient way of resolving disputes. Promoting mediation can resolve disputes. We can also promote mutual understanding between parties, and there will be less tension in the community. That means greater social harmony, and we will have a more inclusive community of mutual respect. To reach that policy goal, the DOJ is working with the Environment and Ecology Bureau and the Food and Environmental Hygiene Department in launching the pilot scheme. This is a pilot scheme for property management agents. We will launch a professional training course to train those officers in dealing with common disputes about water seepage and disputes between neighbors. So we will combine theory and practice in the training session. There will be the basics on mediation. There will also be scenario-based role-playing interactive sessions so that the trainees will develop the practical skills. They will be able to handle the dispute and they can help foster social cohesion. Now, on promoting mediation in the community, we encourage wider usage of mediation as a way to resolve disputes. The government is also keeping an eye on the latest trends in mediation. The 2023 and 2024 policy addresses propose deepening the mediation culture. And in that connection, the DOJ has been looking at this proposal about a regulatory regime for mediation with regard to accreditation and enhancing the professional standards in mediation. This can help strengthen Hong Kong's status as a regional hub for legal and dispute resolution services. So in 2024, the DOJ set up the working group on mediation regulatory system. So we have completed this review on mediation regulatory regime and disciplinary system. We have some preliminary ideas on this point. Once we collate the ideas, we will consult the stakeholders this year. The pilot scheme on community mediation is a key step of the government's effort to promote community mediation. We are blending theory and practice. We want to promote mediation. And in 2024, we also completed the review of the mediation regulatory regime so that we can set out a better professional regime and of credibility. And this will lay a solid foundation for the long-term development of mediation in Hong Kong. With support from all stakeholders and LegCo, these two efforts will go hand in hand. And this will lead to greater awareness and confidence in mediation. We will be able to promote social cohesion, and we will be able to achieve greater harmony through mediation. I look forward to comments from the chairman and the members, and let's all work together in creating a more harmonious community. Thank you. Now, Mr. Shen Ping-hang will speak on this item. He's from the Hong Kong Law Society.
The Law Society supports the government's initiatives to promote mediation as an effective tool for dispute resolution in Hong Kong. A tenet in Chinese communities is to live together in harmony. We have many terms such as yi wo wai guai and wo hei sang choi, showing the cultural importance of harmony to facilitate growth in the community. Community mediation is a vital tool in fostering harmony within our communities. It provides a platform for individuals to address their conflicts in a constructive and amicable manner at early stage of their conflicts, and most importantly, without the need for lengthy and costly litigation. The Law Society believes that mediation should be the first step to be explored in resolving simple daily conflicts as well as complicated legal disputes in Hong Kong. The pilot scheme on community mediation, launched by the Hong Kong government, aims to resolve disputes between neighbors, saving both time and money of the general public. According to the Department of Justice, the pilot scheme will provide training to frontline property management staff to equip them with basic knowledge on mediation and essential mediation skills and techniques, and various mediation schemes available to the general public in Hong Kong. We note that the pilot scheme aims to enhance the overall abilities of participants to serve as the first point of contact for parties facing disputes and strengthen community cohesion, such as to assist the parties to attempt to resolve or narrow down their differences and conflicts at an early stage, and to refer any unresolved conflicts or issues to mediation for proper handling. The Law Society considers that mediation is a distinct profession in dispute resolution. In mediation, the mediator, who is a trained neutral, will assist the parties to attempt to resolve their disputes in a productive and systematic manner. And the mediator is required to perform various professional mediation techniques and skills in different stages of the mediation process in order to facilitate the mediation process. For example, questioning, reality testing, drafting of an enforceable settlement agreement, etc. We note the pilot scheme is not intended to train the participants to become accredited mediators. Despite not becoming accredited mediators, the participants can serve the important role of informing the parties about the availability of various mediation schemes and services in Hong Kong at an early stage. If appropriate, the participants can assist the parties to refer their conflicts to those mediation schemes and services for handling. For example, the Law Society has a panel of general mediators, which comprises of more than 170 solicitor mediators. Solicitor mediators are all experienced practicing solicitors with good knowledge of the legal issues as well as effective mediation skills. Frontline property management staff or the parties themselves may send a joint request to the Law Society free of charge for nomination of a suitable Solicitor General mediator to handle their disputes. In short, the Law Society is committed to support the government's initiatives in the promotion of mediation in Hong Kong. We believe that mediation is the key to building a harmonious society, and we will continue to work with the government and other stakeholders towards this goal. On the current review of the mediation regulatory regime, We noted that the Department of Justice has established the Working Group on Mediation Regulatory System in 2024 to conduct a detailed review of the Hong Kong current regulatory framework for mediation professions, covering various key areas such as accreditation standards, disciplinary procedures, and the structure, role, and function of the Hong Kong Mediation Accreditation Association Limited. Moreover, the working group has made 7 recommendations on the aforesaid matters. The Law Society strongly supports the continuous development and improvement of the mediation profession in Hong Kong, including its professionalism and openness. For example, foreign accredited mediators may also practice in Hong Kong. We support the Department of Justice to commence consultation to collect views from the stakeholders regarding the review and recommendations of the working group as soon as possible. Moreover, we also invite the Department of Justice to formulate and put in place proper safeguards and or supportive measures in Hong Kong or relevant sectors before any reform proposal is to be implemented in order to maximize its effects. The Law Society is happy and ready to provide our professional views on the above review for the improvement of our mediation profession. We believe that the enhancement of the overall competitiveness of our mediation profession will not only reinforce the status of Hong Kong as an international hub for mediation, but also enable the mediation profession to provide adequate support to the proper operation of headquarters of the International Organization of Mediation in Hong Kong. Thank you.
Thank you for your introduction, Ms. Sam.
Thank you. I now open the floor for questions from members. Now the lineup: Mr. Martin Liao, Mr. Jimmy Ng, Ms. Eunice Yong, Professor Priscilla, Mr. Tang Fei, Dr. Junius Ho, Mr. Dennis Leung, Mr. Holden Chow, Ms. Carmen Kam. Mr. Martin Liao. Let's do 5 minutes per member. Question and answer inclusive. So should I start? Yes, please. So the International Organization for Mediation has now been set up, so that puts Hong Kong in a more prominent position as a hub for mediation. I support the DOJ's initiative on the pilot scheme on community mediation. I have a question. So from July 2022 to December 2024, more than 5,500 water seepage cases were received, and then 4,000 cases were resolved with success. My question is, were these cases resolved through mediation or other legal avenues? I want to see how much awareness there is of these resolved cases, and I think offering training to property management staff can help deal with disputes between neighbors. But there are claims that there's a lack of awareness among the public of mediation. So how can we raise awareness to get people to accept mediation as a way to resolve dispute? Now, will we learn from other places by mandating mediation before people resort to the court? Now, this scheme has the aim of providing training for staff from 90 housing estates. The aim is to offer 6 training sessions. Each session will train 20 people, and that means you have just 1 or 2 people from a housing estate undergoing the training. So are we talking about training the trainer program? Or will this simply be a general training program? If it's a general kind of training, isn't the scope too small? Will that affect the outcome? And if so, will we offer more training places? Let's train more people. So 3 questions for the Secretary.
SJ, 3 questions. Right, for the first question, I do not have specific figures at hand because the scheme relating to tackling water seepage is actually under the portfolio of the FEHD. I do not have figures as to how many cases were resolved through mediation. If need be, I can go back and check with the FEHD. But I do have confidence that mediation must have been involved in the process, be it an official mediation proceeding or otherwise. Perhaps there may be other avenues, but in the course, the FEHD takes charge as the mediator. Now, for the second question about awareness, I think it has to do with general awareness about the public on mediation. Now, the member asked whether we will mandate the use of mediation in resolving disputes. In fact, in civil proceedings or other legal proceedings, courts would usually direct the parties to try mediation. Let's say for small claims tribunal, as I understand, the adjudicator will refer cases to the mediation center first, and even at the level of the district court, likewise, the court may order parties to resort to explore mediation first, or you need to report to the court whether this is a successful attempt. And I do agree that as far as education is concerned, we need to enhance the general public's awareness so as to boost the confidence in adopting mediation as a means of dispute resolution. Now, that comes to my third point. For property management agents, they work at the front line and they can help give a boost to our publicity efforts so that if they are trained, they will be in a bit better position to help residents in resolving disputes. Now, about this training sessions and the number of participants, indeed, we are being quite selective. We want to approach not the lowest rank and file staff, but the management or middle managers, so that through this in-depth mediation training course, we can help candidates acquire more knowledge about mediation, and then they'll be able to pass on the knowledge to the junior staff. Indeed, time-wise or resource-wise, it's difficult to hold large-scale training sessions. So we do want to have the knowledge passed down from one level to another. Mr. Jimmy. Right, I prepared the question, but since the question has been asked by Mr. Martin now, I am now in a limbo. Now, about this pilot scheme on community mediation, I'd like to, first of all, commend the Department of Justice for the scheme. As I understand, I have a question about the Hong Kong Mediation Accreditation Association Limited, or the Hong Kong Mall. As I understand, we have the mediation code, and I'd like to know whether there is any statutory power for registered mediators to abide by the mediation code, whether it works as some form of an agreement. That is, if I'm a member of the Hong Kong Mall and I am obliged to follow the mediation code. Now, what stems from this is the second question, and that is under the mediation code. Will the Hong Kong Mall be given powers to penalize non-compliant mediators after passage of, say, a bill, or is it done by way of including the mediation code in the agreement? And will there be any deregistration process involved? Now, first of all, we need to, set the record straight. For mediators, they are not required to be so-called licensed or registered, unlike the legal profession. That is the prevailing practice around the world because we want to create a culture that is mediation friendly, so everybody can be a mediator as a starting point. But then they do have to abide by the code of practice. It's called the mediation code. There should not be, for example, a conflict of interest, and that. Of course, if you are a member of the Hong Kong Mall, then you're obliged to follow the code. During the mediation process, when a mediator has been appointed, both parties will have to agree to include the mediation code as part of the agreement. So there is contractual obligations, which is the right way to go by. It's also binding on the parties. Back to my point. if we don't require mediators to be registered, then there must be other ways to have oversight. Say for professionals, we may have a disciplinary board. The professionals may be deregistered or the license may be revoked. So for the mediation sector, however, even if the registration is revoked, we can't stop somebody to be a mediator. So the approach that we've learned from the Consumer Council is name and shame. We conduct investigation, is a confidential process, but afterwards, having regard to the confidentiality requirements and upon optimization of the mediation code, then according to the investigation findings, mediators may be subject to disciplinary action and that this matter may be released in the public domain. What is important is that the mediators must be reputable and that they must abide by the mediation code. So the starting point for us is to consider making public the outcome of disciplinary proceedings. But of course, this will be subject to our consultation with the sector. All views are welcome. Next, Monsieur Nation. Thank you, Chairman. Well, I support mediation. I have been a mediator, especially a family mediator myself for many years. I see that the government has been making relentless efforts in promoting mediation. Now, I see that there is this pilot scheme on community mediation. The pilot scheme can help solve livelihood-related disputes such as water seepage or other neighborhood disputes. For the cases taken up by the Joint Office, the number has been on the rise. In 2024, 47,000 cases of water seepage were recorded. I see that some 4,000 cases were successfully resolved. They involved private housing estates, and that's roughly 70% of the total. I find the result encouraging because it gives impression to the public that mediation is the way to go, and I understand that a training scheme will be put in place starting from July 2025 to the third quarter of 2026. Now, my question is about how mediation can help members of the public. In Singapore, I understand that a tribunal court is set up to help resolve neighborhood disputes such as water seepage, etc. So very similar to our approach. But according to the SJ's explanation, there is no mandatory requirement in our laws for a case to have gone through mediation first before it is taken to the court. But like I said, in Singapore, they've set up this special tribunal to promote mediation as the first line before the case enters into a legal process. So for Hong Kong, well, is it possible that upon successful implementation of the pilot scheme on community mediation, that the similar approach can be taken? SJ. Well, thank you, Ms. Yong, for the questions. Taking Singapore's approach as an example, when it comes to neighborhood disputes in Hong Kong, very likely the Lands Tribunal or Small Claims Tribunal will be involved. And in fact, in the Lands Tribunal, as I understand, there is a practice direction, especially on building management. So I suppose it also refers to mediation. You can take it as a mandatory requirement as is set out in the practice direction. Of course, we need to work closer with the judiciary in formulating a practice direction in this regard. I do keep an open mind. I do encourage people to try mediation, but still it's a voluntary arrangement. It may not come to any fruitful results. So what is important is to instill in the public confidence in the system as a whole, and that means we need to train mediators. That way, I believe it will be able to achieve a greater success. But of course, I will actively explore your suggestion. Chairman, I fully appreciate that not all cases are suitable for mediation. The DOJ earlier mentioned the same. I'm not suggesting that mediation should be mandated, but let's say if we have an enactment, then the general public will have a better idea what the government is doing, and that is we have a mediation first strategy, and that we should try mediation before taking the matter to the court. Because at the moment, we usually file a case first for litigation, and then we try mediation before moving back to litigation again. I understand that there are practice directions, and even for the High Court, directions will be given, and that you need to obtain a certificate of mediation before joining the queue for litigation again. But what I'm suggesting is to try mediation first so as to alleviate the burden on, say, the Lands Tribunal or the Small Claims Tribunal. As I understand, the Lands Tribunal deals with more complex issues such as the right of way, easements, etc. So I hope the Department of Justice will look into this option as to mandating mediation so as to increase public acceptance. Right, I understand your suggestion is that unless you've tried mediation, you probably shouldn't be allowed to submit a writ. And in fact, nowadays we have something similar. You need to show proof that you've tried mediation. But of course, we can consider other options. But we need to bear in mind the access to justice element. You cannot deprive anyone of the right to have access to justice. That means accessing the courts. Anyway, I will consider your suggestions to see how we can achieve a win-win whilst meeting the objectives. Right, this citizens' right to have access to justice is actually enshrined in the basic law. Professor Priscilla Leung. Thank you, Chairman. First of all, I'm happy to learn that the International Organization for Mediation has set up the headquarters in Hong Kong, and that this is big news for Hong Kong in promoting mediation. It is also a very important step. Now, coming back to today's topic, it is about community mediation. We have a pilot scheme on that, and it's not at the same level as the IOMET that I just referred to. In last year's policy address, the government also announced mediation first strategy. That is, especially for government contracts, there is a new initiative. Well, I joined the Legislative Council in 2009. The first motion that I moved was about mediation. Now, I am a practicing lawyer, and I'm also a general mediator, as well as an integrated mediator recognized by the International Risk Management Organization. So I went through all the training courses. I understand that in general, we have mediators of different caliber. But when it comes to community mediation, I do believe that mediators in Hong Kong are capable of chipping in. But that's, in fact, the crux of my first motion in the Council, because we have seen the middle class living in private housing estates, splurging money to take neighborhood disputes to the court, and in the end, the problem remains whilst all the money went to the lawyers. So it's not a dispute resolution. It's not about right and wrong. We need to find ways to resolve disputes. In fact, these are the tragedies that I've come across over the years. Some people are not meant to be engaged in court proceedings. So I think that in order to become a successful mediator, this candidate should be, say, a social worker, a property management agent, or somebody involved in owner's corporation, and not necessarily a lawyer. Now, my question is for the Department of Justice, but perhaps other policy bureaus could offer an answer. Now, I went through all the accreditation process. I took all the courses. I sat in exams. So for the so-called licensed mediators, we have a very small pool here. So how can we make good use of the accredited mediators? Because in fact, it's a rigorous process. Even lawyers fail in the exam. They act too much like lawyers, and they're not friendly enough as a mediator to help resolve problem in the mediation process. So it is all about making good use of their pro bono service. Say, ask them to help solve water seepage problems, and then they can gain experience and have more exposure, and gradually they can take up government contracts, construction contracts as well, and with improvement in income, overall speaking, the profile of the sector will be raised, and that even professionals or people of high caliber would be willing to join the sector. So my first question is this. I'm thinking perhaps the Home and Youth Affairs Bureau should also be involved, because we're talking about community mediation.
So it's about opportunity. They say they simply have no chance to offer the services. Secretary. I agree with the member. First, to respond to Professor Leung's point. Professor Leung made a good point. The government is leading by example. That's why we have this new policy. In all government contracts, there is this mediation clause. We have to inspire confidence. We have to get people to believe in this. People have to believe that mediation works. Mediators have obtained their professional qualifications. Now we just need opportunities for mediators to do their work. At the West Kowloon Law Courts, there's a mediation center under the judiciary. Professionals with the qualifications can serve as mediators there. Professor Leung also made a good point. Now we're working with the EAB on this pilot scheme. For housing estates, these kinds of cases come up all the time, and I will pass on the message to the Policy Bureau. We can explore a possible register, so when a case comes along, people can refer to that register, and then there are people willing to help out as mediators so that we can have more opportunities for mediators. That's something we can look at. The Home and Youth Affairs Bureau is also familiar with community-level issues. That bureau may also help create more opportunities for mediators to do their work. So I will talk to those two bureaus so that we can see what we can do to help mediators provide the services. So let's also leverage the district councils, because they deal with disputes every day. And that's why I brought out the HYAB. Now, we're not expecting care team members to be mediators. It would be nice if they can do it, but there are many people in the community doing the work, so we can work through the HYAB and the EAB, because these two bureaus are most likely to come into contact with frontline cases. So we will talk to those two bureaus, and we'll talk about getting access to information on people who are willing to offer services as mediators. Mr. Tang Fei. Now we have IOMED. IOMED is for large disputes. We also have to address the community level disputes. Those community level disputes bring to mind the idea of the Feng Chao experience, and that is a professional approach to dispute resolution within the community. And as the representative from the Law Society just said, we should be promoting harmony in the community. Now, for this pilot scheme on community mediation, This is about training property management in mediation skills. So those property management people may deal with dispute between landlords and tenants or between property owners. We need greater awareness among landlords and tenants of mediation. But my question is, does mediation fit in with the duties of property management staff? Say you have two property owners in a row. The property management person cannot just try to mediate straight away. There has to be a procedure for mediation. Say you have a resident questioning the attempt of the property management officer trying to mediate. Then you have a question. Does offering mediation fit in with the property management staff's duties? And what more can we do to help people see the importance of mediation? So will there be a procedure for property management to go through with the disputing residents? Because mediation is more than just about talking to the disputing parties nicely. Now, I believe there will be future pilot schemes of mediation, not just in housing estates. You can do mediation at schools. There's a school-based mechanism for addressing complaints. Of course, addressing complaints is distinct from mediation, but mediation as a professional service can help schools deal with complaints on a school-based level. This can be a dispute between a teacher and the school management, or a dispute between a parent and the school, or a dispute between students. Having mediation at schools can create this culture of mediation among students, and that can make a real difference. Secretary. Now, on whether mediation goes hand in hand with the duties of property management staff, I don't see any clash. In fact, mediation can complement the duties of property management people. That's because the property management staff are there to implement the deeds of mutual covenant. Say, residents disagree over how they should interpret the deeds of mutual covenant. Those people turn to the property management. So as a first response, disagreeing residents turn to the property management when they disagree over what the deed of mutual covenant means. So mediation skills help here. Because in this case, the property management can help the residents make sense of the deed. So these mediation skills will help. This will help property management better do their job in implementing the deed. Now, our training program is not meant to turn property management into professional mediators. We're simply giving property management staff the skills and the spirit behind mediation. Now we want the property management staff to try to reason with the residents as a go-between person. We just want to give these people the basic mediation skills. They do not have to be professional mediators. The substance matters more than the label of whether someone is a mediator. Now, on whether we can apply mediation to schools, I support such a proposal. I would like to see mediation being made part of everything we do, but we have to get our priorities right. So we will get to that at some point. Now, for people trying to become principals, they have to go through training. So maybe you can make mediation part of that. So I'm happy to explore this idea with Mr. Tang. Next, Dr. Junius Ho. I support the pilot scheme on community mediation. The 2 sessions was held this year. At the courts of first instance in the mainland, they have 46 million cases each year. And then you have a separate case load for the Supreme People's Court. And that means for each judge, they take out 353 cases, and you have 110,000 judges in total. That's a lot of work for the mainland judges. Now, for the 46 million cases, millions of such cases have to do with minor disputes. Disputes over lease or business, commercial matters. Those matters can be sorted out through arbitration or mediation. And then in April, the University of Political Science and Law issued an article, Mediation Before Litigation. That approach can deal with many cases before they even reach the court. Arbitration and litigation are mutually exclusive. You have to rely on the contractual clauses. If parties disagree, you go to the court. But the mainland is a step ahead in this matter. So their approach is to go for mediation first, and then you go to arbitration, and then you go to litigation if everything fails. When everyone turns to litigation first, there is a huge social cost for us. We want to shorten the time it takes for court cases in litigation. So that's why I'm sharing the development in the mainland. The mainland is making such groundbreaking moves. So coming back here, when you have minor disputes like management disputes, you know where the parties are, you have property management there. There are consequences for water seepage. So the sequence should be mediation first, and then arbitration if mediation doesn't work, and then litigation should be the last resort. So I support this approach. Now, I just want to share a few thoughts on community mediation. So I support this pilot scheme. For this pilot scheme, sure, let's start with water seepage cases, but we should be expanding the scope in phases so that we can cover other petty disputes under mediation. When a case goes to the small claims tribunal, the presiding officer asks those parties to talk things out themselves. So we should be expanding the scope of mediation. We have 1,800 justices of the peace. But these people can play a bigger role. We have 13,000 solicitors and 1,700 barristers. These people are already qualified. I just heard that we don't need a license for mediators. But the lawyers I just talked about have legal training, so let's make the most of them. And we cannot just force people to accept a result. What we should offer is recognition. We show respect for the parties. So in the fee, for duty lawyer service, there's an application fee of $680. So for mediation, we should set up the sequence. You start with mediation. If it doesn't work, you go for arbitration. If that fails, you go for litigation. And the fee should be charged on a user pays basis. Once we have this arrangement, you can have solicitors from the law society serving as mediators, and then we can solve all kinds of social problems. That's my idea. Thank you.
SJ. Thank you, Dr. Junius Ho, for sharing in great detail with us the mainland experience. I fully appreciate that. I do think that this applies to Hong Kong, as we all want to save time and resources. So we'll try to expand the scope as much as we can so that we have wider participation and greater recognition. So I'm fully on board with Dr. Junius Ho, especially on recognition. Because if you want to look professional, if you want to gain recognition, you need to strike a balance, bearing in mind the public's affordability. So as I understand, if need be, legal assistance can be provided to parties to mediation. On resource allocation, we will be more proactive to enhance public acceptance. Why not adopt the duty lawyer scheme model? Yes, I note that. I thank you for your comments. There are also other suggestions coming from Dr. Junius Ho, legislative amendment to put mediation before arbitration in the process. Well, I think the principle is to encourage mediation, not in a mandatory form. We do need to consult different parties about how we should go about it, or whether we should resort to legislative path. Let me supplement. SJ, as you know, you're also a practicing barrister and a senior counsel. Now, I am not suggesting for civil proceedings that mediation must come before litigation. But when it comes to the day when we reach a certain milestone, we should ask for mediation first, and you need to obtain a certificate before the proceeding goes further. So this is already in place as part of the system. Now, in fact, in court procedures, or perhaps in the civil procedures ordinance or rules, we can stipulate, for example, for a personal injury case, before you send a letter for action, you should include all these elements. Now, this is actually laid down in the code. So I'm suggesting that before the matter reaches the court, we should try mediation, and you should also try arbitration as an alternative dispute resolution. That's ADR, so as to lessen the burden of judges. The matter may be trivial in the first place. There are other ways to resolve the dispute. So we should prioritize the matter. That is not a hindrance to access to justice. We're trying to make sure that the whole process can remain smooth. Right, noted. Next, Mr. Dennis Clark. Thank you, Chairman. Well, I thank the administration for putting in place measures to promote mediation, so as to resolve community mediation without posing extra burden on the courts. I fully agree with the 7 recommendations in the paper. The mediation code should be reviewed to enhance the recognition of the mediation sector. Now, I have 3 questions. As I heard from SJ just now, at the moment, the courts would encourage parties to resort to mediation first, such as the Small Claims Tribunal. Now, I came across such a case. The judge may ask whether the parties would like to go through mediation first, but if one party rejects, then that's the end of the matter. is there a way to mandate mediation? Will there be penalty imposed on the refusing party? Because I don't think it's fair for the party willing to use mediation. The second point is about water seepage. I understand the community mediation pilot scheme covers water seepage, but apart from water seepage, there are various community issues such as noise nuisance. In fact, in this legislative session, the Environmental Protection Department will put in place a piece of legislation regarding noise generating works in domestic premises that cause nuisance. So apart from water seepage, noise is a major issue in residential neighborhoods. Since the FEHD is under the EEB, my question is whether the same problem can be dealt with altogether. Now, the third question is about training, the 6 training courses and 20 participants. I think the number is on the low side. How do you select participants to undergo training? Do they involve property management agents that can help resolve water seepage disputes? After going through training, do you expect the dispute resolution rate to be enhanced? SJ, 3 questions. Well, after all, it's a voluntary arrangement. Even if one party agrees, the other party is entitled to refuse. And in fact, for family court, there is this rule. If for no reason you reject mediation outright, you don't even want to put your heads together with the other side, then even in the end of the day, you win the case in court, you may still be required to pay costs, deducting up to half, for example. So it's a way of providing an incentive. That is, if you show sincerity in trying mediation, even if in the end of the day it doesn't work, then you will be able to pay less in terms of legal costs. The next point is about training. Water seepage is used in the paper as an example because water seepage is a very complicated issue comparing to other domestic disputes. For example, we need to trace the source of water seepage, whether it happens upstairs or downstairs, and the time spent on tracing the origin takes disproportionately a large amount of time. I have the personal experience as well. Even when you engage an expert, it still takes a lot of time to figure things out. And you will find in the end of the day that this is just out of proportion. So the merit of mediation is that it saves time. But in terms of the training sessions, they include more than just water seepage. They involve different building management problems and the skills for, say, the property management agent to keep the pressure down. And we also educate them about some skills and also a further understanding of the building management ordinance, which can help solve water seepage problems and other building management issues. Right, the third question is about 120 participants in the training sessions. Of course, we want to have as many participants as possible, but at the same time, we want to arrange in-depth courses. So we need to be selective. We can't just take it on board everyone. We need to work with the EEB and the FEHD. We also need to identify the right candidates in the property management companies so that if we train the managers, they may be able to train their junior staff after the after the training course. So it's kind of trainer model. We don't just accept general enrollment. We want to make sure that we can maximize the benefit. Mr. Mike Holden Chow. Thank you, Chairman. I support the pilot scheme on community mediation. And let me share with you my view. First, about mediators. 2 years ago, I remember we paid a visit to the judiciary. Now, the Small Claims Tribunal is a very popular establishment. It is very effective, but in recent years, it has seen a surge of workload. So my experience is that in fact we can make use of the mediation center right next to the West Kowloon Court building. And also, I remember 2 years ago I raised the same point. I have friends who are accredited mediators and they are on the list, so to speak. They can provide pro bono service. In fact, 2 years ago, I raised the same point to you, SJ. They may offer pro bono service, but I wonder if some sort of honorarium can be given to them for the service they provide. About the pilot scheme on community mediation, I understand, as suggested by EBRAM, after training, mediators can offer pro bono service. So it's a very good scheme. I think we should go ahead, but at the same time, honorarium should be given to mediators for their time spent in providing service. So shouldn't we think about it? For all the help mediators have given, I do think honorarium should be provided. Second point. Water seepage cases. I fully agree that we can save a lot of hassle by resolving the dispute through mediation early on. Because otherwise, like the SJ said, you need to engage a surveyor to help check and trace the source of water seepage, and it's a lot of hassle. So I think you should enhance public education to let the public know that mediation is the way to go, and we should try our best to use mediation service first. Now, because as you know, 10 years ago, the administration already referred to the civil justice reform, and that you might have to pay cost if you lose in the court. So you might as well go for mediation. I think the message that we should send to the public is that mediation works. Mediation resolves disputes. We're not just going through the motion. So I think public education is likewise very important. SJ. Well, I agree with you about fees for the mediators. This is a general principle. Of course, if the parties involved are of means, they may be able to pay more. But for small claims, because of the smaller amounts involved, if parties are required to pay the mediator for the service, then this may pose a hindrance. They may have reservations about using mediation. But at the same time, I acknowledge your point. We can't always ask mediators to provide pro bono service. It's a matter of resources. I think this is a matter close to the heart of members. We are concerned about the government's fiscal position, and that, similar to duty lawyer scheme, can we have duty mediation scheme as suggested by Dr. Junius Ho? But does it work? Where does the money come from? Because for small claim cases or building management, if services are provided at a fee, then this may hinder our efforts in promoting a wider adoption of mediation. So, on publicity, similarly, this can help make things successful. Well, for example, the success rate of the mediation center at West Kowloon Court Building is 66%, so more than 50%. So at least we leave an impression with the public that it is a successful way of resolving disputes. So we'll try different approaches to enhance confidence in the public.
同埋一個
I have to draw the line for this item here. 2 more members are waiting to speak, followed by another member who wishes to follow up on certain points. Ms. Carmen Khan, first, I congratulate the HKSL government for the signing of the Convention on establishing IOMED last week. And this shows our country's commitment to turning Hong Kong into a hub for mediation. In Chinese culture, harmony comes first. And the government is leading by example. There are mediation clauses in government contracts, and now we also have the pilot scheme on community mediation. This is a 2-year scheme. We start with property management agents. We start with water seepage cases, and that's only right. That's because the Ombudsman has come across cases of disputes involving the Joint Office on water seepage. Many disputes involved residents over water seepage. So we're making a good choice by picking water seepage cases. This scheme will go on for 2 years. The new director of the liaison office, Mr. Zhou Ji, mentioned 3 key players in district governance: care teams, the 3 committees, and district councils. These 3 key players can play a role in promoting the mediation culture. So let's get these players involved in promoting mediation in the community. I also welcome the review of the mediation regulatory regime. We just heard the briefing from the Law Society. We should indeed review our mediation regulatory regime. How far should we go in regulating the industry? I see 7 recommendations. I see the pros and cons laid on the table for us. I can see a balanced review. It's not just about where we're doing well. Should we or should we not have accreditation? Elsewhere, some countries go for accreditation. Should we have just one authority? Some countries do that. But applying that to Hong Kong would involve fundamental changes. So I can see the working group has produced solid results. I have a question for the Department of Justice. So will this working group continue its work until the measures are proposed? The paper says for these 7 recommendations on the regulatory regime, so there will be analysis of the pros and cons, and then there will be the specific measures. So I wonder, will the working group have to endorse the measures before they are launched? The first, I thank Ms. Khan for suggesting that we get the stakeholders involved. We will where we can. Now, for this working group, they have done this full review. They looked at the experience of 14 jurisdictions before coming up with the 7 recommendations. The DOJ will set up an expert panel of legal and dispute resolution services. We had a discussion last month, so everyone supported the recommendations, we want to go wider in our consultation. The paper says within this year, and that's in paragraph 10 in the paper. Before recommendation 1, we will have a more extensive consultation. So we have this expert advisory group. They have looked at the proposal, but then we will also consult more extensively on the 7 recommendations. Our next step will hinge on the findings of that public consultation. Some measures may warrant legislation, but not for others. One recommendation is to give the HKMAL the statutory power to appoint a mediator when the parties disagree. That may warrant legislative changes, but other measures may not need changes to the law. Say the HKMAL may have to revise or enhance their own code of practice. So everything will hinge on the outcome of this extensive consultation before we decide on the next step. But we will finish the consultation within this year. If further steps are needed, say changing the law, we will have to consider the timetable. So is this working group still working? They will continue to monitor the situation. Now we're talking about an interactive process. So we got the feedback from the expert advisory group within the DOJ. Will have to enhance the proposal. In the end, the DOJ will have to come up with a specific proposal to implement the 7 recommendations, and that will require the work of the working group so that the DOJ can come up with a detailed proposal. So that working group will keep putting in the work. Next, Ms. Doreen Kong. I support the pilot scheme on community mediation. Now, I have been offering services free of charge for a long time. There were many disputes in housing estates. I thank the Secretary for coming up with this pilot scheme. I've done my research into building management. I just did my doctor's thesis on this matter. Now, under the Home Affairs Department, there are free mediation services. Between 2018 to 2023, in Tai Po and Sha Tin, both densely populated districts, in Sha Tin, in 2022 to 23, under this scheme of the HAD, there was no case that used the free mediation service, and in Tai Po, there was just one case where the service was used. Now, I hope people will get involved under the DOJ's new pilot scheme. We can train up a bunch of mediators, like the HAD has offered free mediation services, but you need people to buy in. I just got my figures from the government. So we need a market. I'm not saying it's a bad idea to train property management staff. Those people know building management, but how do we guard against conflict of interests? The building management market is small. There are just a few dominant players. Will we have a mechanism to guard against conflict of interest? When I did my research on building management, I talked to the incorporated owners in Sha Tin's housing estate. Those people said they believed in mediation. They tried mediation many years ago. So they turned to retired judges. They had faith in those retired judges because the sheer presence of those retired judges got the problem solved. So will we consider something similar for our scheme? So for the pilot scheme, let's broaden our scope. Many people may want to get involved. I want to serve as a mediator under this scheme. My focus is more on property. I want to learn about this through providing the service. So can we broaden the scope? Now, in Singapore, they have a community mediation center. There, they have a tiered system for mediators. Some mediators are more experienced than others. And then they also have mediators grouped by district in Singapore. And at this community mediation center in Singapore, they also have an advisory committee. So they have their own mechanism to manage the whole system. Now, there are more actions I would like to see, and it's about training of mediators. And I'm not just talking about training of community mediators. Now, people need 40 hours of training to become a general mediator, and it costs $15,000 in Hong Kong. Other places offer more flexible options. People can take online courses to become a mediator, and those training sessions elsewhere are cheaper. We want to promote mediation in Hong Kong. People attending the training in Hong Kong have to attend weekend sessions. They cannot skip a single session, otherwise they have to take makeup classes. We are not taking a modular approach. People have to do their 40 hours of training in one go. In Singapore, online courses are an option. They do a modular courses. People have flexibility in attending training. Can we have cheaper mediation training in Hong Kong? Can we offer people greater flexibility? If we can do that, we may have more mediators and we will be able to promote mediation culture. The member brought up the staggeringly low success rate of certain schemes. I have no idea why that's the case, but some recent figures give us cause for hope. Now I'm looking at the Small Claims Tribunal. Their success rate in West Kowloon was 66%. And now we have a partner, and that's eBram. And they offer this pro bono online dispute resolution platform. In early 2025, they got 70 inquiries, and they also handled a number of cases. So it's hard to say whether we're dealing with too few or too many cases, but there is a real demand for mediation. And we will keep working on this. Now, on whether we will broaden the scope, we hope we can do that, but resources are a problem. Now, we have to find a place to start. Everyone wants the service, but we have to get the priority right. We do see many cases involving water seepage. And other policy bureaus have also come across this problem. So we are all agreed that this space is where action is needed. So we start with water seepage. This is a start, not the end. Now, I also agree with the member on guarding against conflict of interest. This is where caution is warranted. You don't need real conflict of interest. Even the perceived conflict of interest will hold things back. And that means education matters. To be a go-between person, you have to have several things in mind. You have to be clear. First, you have to follow the law, and you also have to present yourself as an impartial figure. And this is also in the code of practice for mediation. You have to appear to be impartial. And we will be focusing on that during the training we offer. And when the conflict of interest is real, there may be legal liabilities. We want to get the message across, and people will be more alert to that. Now, on whether we can replicate Singapore's model, can we have district-based mediators? Can we have tiered mediators? We now have district councillors, we have care teams, we have the district committees. Those people are happy to help. Now, we can certainly explore the idea of district-based tiered registers of mediators. That way, people can access the mediation services they want, and people who want to offer the services have a way to do it. Now, on fees for mediation, fees for mediation training, the government is not taking the lead. We cannot dictate the training fees. This is a market-oriented matter, but we will be talk to the industry. Now, online courses or not, it's about flexibility. We want to make sure the training is professional. There will be requirements about the hours of training so that people receiving the training will be up to scratch. We can certainly explore flexibility. After all, we can use technology. Fees are a matter for the market to decide. The government should not be intervening and dictating the fee. So the fee will depend on supply and demand in the market.
Well, as we are behind schedule for this item, I will only allow 3 minutes for Professor Priscilla Leung in the second round. Thank you, Chair. First of all, I fully support the mediation. I also took part in the disputes between victims and the Lehman Brothers. The case involved several 10,000 victims, and the case was finally settled with the bank, and later on, we resorted to the Financial Dispute Resolution Center with a maximum compensation amount of $500,000. I later on took part in another case involving the California Fitness and also a dental clinic, again involving many consumers. Now, these are cases ideal to be resolved through mediation. So I want to make it clear at the outset that, in fact, 10 years ago, I also raised the same point for mandatory or compulsory auction. We should go for mediation first. I had the support across the political spectrum, especially those with legal background, but in the end, we didn't manage to push it through. So at the outset, I want to say that policy should come first. For example, you have practice guidelines or practice directions in courts. Now, I have this suggestion for the administration. But first, I need to declare that I am assisting parties which would like to resort to mediation, and the other party is the government. So on the part of the government, the easiest way to go is to let lawyers do their job, because if no lawyer is involved, then it may be an even greater hassle for the government department to be involved in the mediation and settlement. So I hope that something will be done to promote mediation as the first line of dispute resolution so that we can save legal costs and also save money for the government. When it comes to fees for mediators, I understand that in some jurisdictions, mediators can charge a fee, especially after you've taken the international integrated mediation course. You can charge a fee at a certain percentage. So on the promotion front, I hope the Department of Justice can take the lead and give more opportunities for mediators without the legal background to join the race, so to speak. It's not just for lawyers. There are different types of mediation processes that other kinds of mediators may be more suitable to join. Just very briefly in response, when it comes to disputes involving the government, whether the government departments should try mediation first. Well, I say that even before we promulgate any policy, the matter will land in the hands of the civil division of the Department of Justice, and they do encourage the government departments to try mediation. The second point is about mediators without legal background. There is no policy to give priority to mediators who are also lawyers. anyone who is interested in becoming a mediator can have a go, and we will try to be as inclusive as possible. This is our policy. Right, that wraps up this item. Thank you, SJ. We now move on to the next item, which is promoting law tech and latest developments of the judiciary's use of technology in court operations. Let's invite the team to come in. Members, if you want to speak, please press the request to speak button now. Now, for housekeeping, I will give each member 4 minutes, question and answer included. Right, without further ado, I will invite Dr. Horace Zhang, Deputy Secretary for Justice, to take us through this paper. Thank you, Chairman, members. With rapid developments in technologies, the legal profession is now facing an unprecedented digital reform. Now, the recent changes in the legal profession is that big data through the internet is available together with AI technology. All these tools are available to the legal sector. The objective of law tech is to enhance the legal delivery of legal services, efficiency, and user experience. Now, law tech is not the same as Internet Plus because law tech emphasizes the efficiency in the delivery of legal services to ensure automation and delivery of services in a smart manner. Now, this is already the prevailing trend in the international community, and likewise, we must also embrace law tech so as to bolster our status as a legal and dispute resolution hub in the APEC region. Now, the Department of Justice fully supports the use of law tech to enhance the competitiveness of our legal profession. We've been adopting strategies to promote the adoption and development of law tech in Hong Kong. Let me go through very briefly with members the various initiatives on the promotion of law tech and the results. There are 3 major strategies in the use of law tech in Hong Kong. That is an online platform, hardware and software. Since 2018, the government has been developing online dispute resolution and deal-making platform. And with the support of the government, eBram International Online Dispute Resolution Center has since 2022 developed a series of ODR platforms, including the APEC ODR platform, online arbitration platform, online mediation platform, as well as the deal-making portal to facilitate business transactions and access to justice on hardware and software. The Department of Justice in 2020 established the Law Tech Fund to facilitate small and medium-sized law firms and barristers' chambers to upgrade their information technology systems and related skills. Now, the fund was widely supported by the legal sector. Since its establishment, we have received applications covering 70% of the target firms and chambers. Now, the other initiative is the Hong Kong Legal Cloud Services rolled out in 2022. Eligible subscribers, including solicitors, barristers, arbitrators, mediators, etc., could take out the 3-year subscription. As of February 2025, over 4,000 subscribers were subsidized. Last year, the chief executive announced in the policy address the establishment of the consultation group on law tech development, so-called the consultation group, to help formulate measures and policies relating to law tech. so as to enhance efficiency and the quality of legal services and enhance the competitiveness of the legal profession. The consultation group was set up in January this year. The group comprises legal and dispute resolution professionals, law schools, as well as other experts on law tech. Meetings are held on a regular basis for recommendations to be made to the Department of Justice and to lay down some objectives. Now, including the following. A roundtable series and other events related to law tech will be organized within this year to facilitate cross-fertilization experience sharing. The Standing Committee on Legal Education and Training will also be engaged to enhance the use of AI or Gen AI among law students. The third point is about the publication of a roadmap and also ethical and security guidelines for a more effective adoption and utilization of innovative technologies. The DOJ will review the situation and will continue to draw up long-term action plans. In the long run, the Department of Justice seeks to enhance the relationship between law tech users and legal practitioners so as to make technological breakthroughs and to create a new model that can be conducive to the ecosystem of the legal profession. The DOJ will continue to work closely with the consultation group. It will also consider the groups and the sector's advice so as to promote a shift in the culture of adopting law tech in the legal profession. It is believed that the competitiveness of the legal profession will be greatly enhanced with the assistance of law tech, which can help consolidate our position as an international center for legal services and dispute resolution in the APEC region. We invite members to continue to support us and promote wider adoption of law tech in Hong Kong. Thank you. Next, I will invite Ms. Esther Leung, Judiciary Administrator, to walk us through their paper. Ms. Leung has prepared a PowerPoint-aided presentation. I believe the PowerPoint materials have already been distributed to members before the meeting. Thank you, Chair. Please switch on her mic. Switch on the mic for Ms. Leung. Yes, Chairman. You mentioned the PowerPoint presentation, Chairman. At the appropriate juncture, I will start this PowerPoint presentation as I deliver opening remarks. Chairman, the judiciary has been proactive in promoting the use of various technologies to enhance the operation efficiency in court operations. We made a report to the panel in November last year, and we have made some major developments in various areas on the use of IT, and I'd like to brief members on these areas. The first one is Integrated Court Management Case Management System, or ICMS. This is a major technology initiative for our court system to become digitalized, and electronic copies of documents can be are filed in our system for inspection, for filing, and also we allow electronic payment through the system. The first phase was introduced in May 2022 at district court and magistrate courts level. As for the second phase, starting from October 2024, the ICMS has been expanded to cover bulk claim cases of the Small Claims Tribunal. Now, in June, on the end of June this year, this will be gradually extended to civil proceedings of the High Court. And our plan is to further extend the use of ICMS to the CFA, the criminal procedures in the High Court and DC, as well as non-summons courts of the magistrates, courts. As in April this year, over half of the law firms registered in Hong Kong have registered for accounts under the ICMS. The number of new cases also increased to about 70%. In the past 2 years, the judiciary has been rolling out various measures to facilitate the users. For example, we offer a 20% fee concession for 5 years and 3 years, respectively, in 2 phases. We also have a dedicated website. We also hold face-to-face briefing sessions and demonstration sessions online. Now, in the following, I will make use of the PowerPoint materials to explain the optimized or enhanced version of ICMS in the end of June this year, when the system is extended to the High Court. There will be new functions. In fact, recently, just on the 30th of May, with the help of the Law Society, we held a briefing session. And allow me to take this opportunity to walk members through the content. After extension of the ICMS to the High Court, there will be new functions included. First, about the scope. 11 categories of cases will be incorporated. Following a timetable, the cases will be included in a progressive manner. Starting from June 2025, this system will deal with civil appeal cases, followed by commercial litigation, etc., so that there is a timetable for the sector to follow.
Now, I want to walk members through the new features one by one. First, generating originating documents. By this, we're saying that the parties can use this system. They can create originating documents in standardized formats. So you initiate a case, the practice will be standardized. That's to help the ICMFs gather data. In the future, parties won't be able to just scan an image of the document. The system will also enable e-signature for verification. The second feature under the new arrangement is that we know the High Court deals with a much larger volume of documents than district courts do. Now, there's a cap on the size of each document to be uploaded at 50 megabytes. At the High Court, we will progressively increase the storage for organization users because we will be using the judiciary's cloud. That way, files of different sizes will be able to be stored. Now, for each user, we will provide 20 gigabytes. That's the second new feature. The third new feature, this is also in response to calls from the legal sector. At the High Court, we will allow organization users to set up their deposit accounts. So this will be an extra option. Law firms can pay an amount that is no less than $3,000 as initial deposit into this account. They will be able to activate the account. With this account, the law firm will not have to pay for each and every transaction. Once the balance falls below $3,000, the law firm can top up the account, and that will give law firms more flexibility in handling transactions. Now, I turn to the third new feature. And this is something from our experience in going electronic. There will be a new rule from the High Court for all parties. It doesn't matter whether you are a department, a law firm, or an unrepresented litigant. If you choose to file or submit a paper-based document, you must provide an e-copy of that document at the same time. We're taking that step so that we have the full set of e-filing records, so that court users will be able to inspect all the files filed electronically, and we can also ensure consistency between the paper copies and the electronic files. And for the e-copies, there will also be guidelines on how you can go about filing the documents. Now, for law firms and legal representatives providing the paper-based documents, they will have to scan the documents, and they save the file onto a USB drive. They upload the files at the self-service kiosks. For unrepresented litigants, they will be able to scan and upload the files at the self-service kiosks. Now, we have created a short video on how people should go about those steps. Now, on our website and also on LinkedIn, we have put out this video because we still have a month to go from now to the end of the month. So there's a month's time for people to get ready. Now, for people from law firms, this is our last step in the transitional arrangement. We have been saying this for a long time. Starting from next year, at an appropriate time for select cases, all legal representatives must use the ICMS. So within this 6-month window, we still give law firms an option. This is the last step in the transitional arrangement. So we hope the legal sector can start signing up for the ICMS if they haven't done so, and start using it. We want more users on the ICMS that will save money and save manpower for everyone. And you will get the benefit of filing documents anywhere. Extensive publicity will continue. At the High Court, we will provide assistance so that users will be aware of the details, and we will help people get used to the new system. Now we want to turn to remote hearing. Now, the court's remote hearing ordinance was enacted. In fact, the ordinance commenced operation on the 28th of March this year, and that provides a clear legal basis for judges and judicial officers to order remote hearings at various levels of courts and tribunals where appropriate. Now, on stepping up the use of remote hearing, the judiciary is also prepared to conduct remote hearings more often in suitable proceedings, such as 3-minute hearings and non-trial criminal proceedings, such as bail applications. So the judiciary is prepared to hold remote hearings more often for those cases. The judiciary is also making an effort to provide live broadcasting of court proceedings outside court premises. That's to ensure greater transparency and enhance public awareness of our procedure. In 2024, for 4 selected cases, we tried live casting. We did those trial runs. So in April this year, we started this 2-year trial scheme where for suitable appeal cases, substantive appeals, we started trialing live casting. Now, but then there are cases where live casting doesn't work, such as cases where we need to protect the interest of children or the mentally disabled adults, or privacy interests, trade secrets, or commercial confidentiality. For those cases, we don't do live casting. After each live cast, the videos will be uploaded to the website of the CFA. The video will be up there for a month for people to access. Once the 2-year trial scheme concludes, we will review the experience, and then we can consider the long-term arrangements for live casting of court proceedings outside court premises. Now, I turn to generative artificial intelligence. The judiciary has been keeping an eye on the experience in other jurisdictions. We looked at their guidelines. So last July, we released our first set of guidelines on the use of generative artificial intelligence for judges and judicial officers and support staff. Now, while we ensure justice, judges and judicial officers can use, and that is making prudent and responsible use of generative AI in the course of their work where appropriate. Starting from 2023, the Judicial Institute has been exploring the use of generative AI tools. Our trial shows that when it comes to legal analysis with professional input, AI tools leave room to be desired in terms of reliability, especially when it comes to accuracy, consistency, and transparency of logic and reasoning. AI tools are not fully reliable, but the judiciary will keep an eye on the trends in the use of AI tools, and we will be reviewing and amend our guidelines when appropriate. Now, on the other technologies and other initiatives, those details are set out in the paper. I do not propose to go into the details. The judiciary will continue to make active use of technology to achieve greater efficiency in court proceedings. We will also stay alert We will guard against the security risks in the use of technology at court. That's all from me. I'll stop here. Thank you. Next, we will hear from Mr. Brian Chow, barrister from the Hong Kong Bar Association. 5 minutes. Thank you. So I'm from the Hong Kong Bar Association. I welcome the efforts of the DOJ and the judiciary to promote the use of technology, and I welcome the progress we have achieved. I want to comment on the ICMS in particular. The usage, the uptake is nearly 70%. And that shows a growing recognition of electronic ways of doing business, so we can finally put facsimile behind us. Now, we do have some ideas we want to share for small and medium law firms and also larger barristers' chambers. Starting from next year, we will be mandating the use of the ICMS. We would like to see targeted technical assistance on the use of AI-powered tools. The HABA support the approach taken by the judiciary, and that is advising against the use of AI in judgment writing. AI as a judge would be scary. And we should also enhance the data protection regime. And on system development, which is our fourth point, we argue for greater engagement with industry stakeholders. We should be doing scenario testing. Overall, the Hong Kong Bar Association supports the use of technology to boost judicial efficiency and transparency. We look forward to working closely with stakeholders. Thank you, Chairman. Thank you. Next. The next one to speak from the Hong Kong Law Society, we have Mr. Amirali Nazir.
Justice and the members of the Legislative Council, good afternoon. On behalf of the Law Society of Hong Kong, I would like to take this opportunity to share our views on law tech and initiatives of the Law Society in promoting technological advancements. The Law Society recognizes that artificial intelligence and other emerging technologies are reshaping the practice globally. The Law Society has been planning ahead the promotion of legal innovation, ensuring our members are equipped with the necessary knowledge and tools to navigate an era of rapid digital transformation. AI has been a standing item on the agenda of our Inner Tech Committee since 2020. In January 2024, the Law Society issued a position paper on the impact of AI and on the legal profession. As outlined in our position paper, the Law Society has committed to a strategic roadmap that aims to guide the legal community into the transformative impact of AI. A three-phase approach was proposed to be adopted. The first phase, inform, second phase, engage, and the third phase, implement. Phase one of this roadmap, aptly named Inform, focuses on building awareness, understanding top challenges, and curating essential resources. The centerpiece of this first phase was the launching of a dedicated web page, AI Resources Hub, on the members zone of the Law Society official website in May last year. The AI Resources Hub was constructed with a view to contributing to a comprehensive understanding of the impact of AI on the legal profession, and it provides practical guidelines and training materials on AI applications in legal work. As part of this first phase, the Law Society has launched a members survey to better understand the challenges members are facing with adoption of AI and indicating their top issues and needs. As the Law Society progresses through other initiatives on our roadmap, the AI Resources Hub will continue to evolve, serving as a dynamic platform that supports our members throughout the AI-driven journey. In addition, the Law Society has been providing continuing professional education to its members, enabling members not only to keep updated on technological developments, but also enhance their practice management skills to facilitate transitions to more advanced business models that can fully leverage the benefits of revolutionary AI tools in legal practices. Through the Hong Kong Academy of Law, the Law Society has rolled out and will continue to roll out targeted CPD courses covering the application of AI and generative AI. Beyond education, as the Law Society moves into phase two of its roadmap, We are actively engaging with stakeholders on AI strategies, and we welcome the Department of Justice's establishment of the consultative group on law tech development early this year, where the Law Society is represented and provided suggestions on directions for promoting law tech development in Hong Kong from the legal profession's perspective. As outlined in our position paper on AI, the Law Society takes the view that core principles such as data protection and governance, security and safety, transparency, disclosure, and proper human oversight should underpin AI development in legal practice. To this end, Principle 1.07 of the Hong Kong Solicitor's Guide to Professional Conduct was developed to address ethical issues arising from the use of information communication technology by solicitors. Additionally, coordinated efforts are needed for the formulation of ethical guides on the use of AI as the use of AI expands into court and government operations. At the AJLS panel meeting on 25th November 2024, the Law Society raised a number of suggestions regarding the use of law tech in court operations, some of which have been addressed by the judiciary in today's meeting. The Law Society supports the judiciary's efforts to promote a wider use of remote hearings for civil proceedings, including for short proceedings such as 3-minute hearings, and non-trial criminal proceedings such as bail applications. We believe these initiatives will enhance the efficiency of court proceedings. The Law Society is also keen to maintain close communication with the judiciary on practical implementation of these initiatives so as to ensure a smooth rollout. The Law Society appreciates the judiciary's efforts in providing training and effort to the legal practitioners in adapting to legal reforms in the past. Building on this foundation, we hope the judiciary will continue efforts to organize more seminars or webinars to familiarize legal practitioners with the use of new measures. Such engagements would promote broader understanding and facilitate the effective adoption of law tech in court proceedings. In addition, as suggested in the aforementioned AJLS panel meeting and in our subsequent meeting with the judiciary in March this year, the Law Society advocates that the ICMS be enhanced to provide a non-stop service that includes e-filing, e-service, and obtaining a sealed writ of summons through the same platform. While we recognize that this may not be immediately feasible by architecture or policy, we hope it remains a long-term stage 2 goal for the judiciary. In our submissions to the judiciary in November last year, we also suggested that the scan document function at the self-scanning kiosk at the High Court building be available to users by legal representatives rather than strictly restricting it to litigants in person. This change would save time and cost of legal representatives having to return to their offices to scan the frank documents and then return with the images on USB. We believe that adopting the same proposed measures will enhance efficiency, streamline legal procedures, and ultimately improve access to justice for all parties involved. Lastly, the Law Society would like to take this opportunity to share that we are one of the founding members of EBRAM International Online Dispute Resolution, and we have been implementing law tech in our operations in recent years. For instance, the 7th Belt and Road Conference organized by the Law Society in November 2024, the Law Society engaged EBRAM as its law tech sponsor, where EBRAM provided advanced real-time transcription and translation technologies that ensured seamless communication throughout the event. Looking forward, the Law Society will continue to encourage and equip the legal profession to embrace law tech in an ethical and professional manner. While the legal profession may encounter challenges in developing and deploying law tech, these challenges would also present valuable opportunities. Thank you, Chair. Apologize for overrunning.
跟住咧就係委員嘅提問。
Right, the floor is now open. We're just 10 minutes away from the scheduled end time, so I'm going to extend this meeting by 15 minutes. First and foremost, Ms. Maggie Chan will be the first to speak. 4 minutes. Questions and answers. My first question is about the integrated court case management system. It's a question for the judiciary as well as the Deputy Secretary for Justice. Now, according to paragraph 4 about utilization, 50% of law firms have registered. That's about 49.4% from the number of court users. The second point is this. There is still 6 months to go before the rollout of the next phase of ICMS, and 50% of the law firms have not signed up for the system. So they will have to do that within the 6-month period. At the same time, the judiciary has made tremendous efforts in implementing the initiatives. Now, I'd like to commend them, but there are a number of issues. First, about scanning documents for court proceedings. As mentioned by the representative of the Law Society, there may be abundant documents to be scanned, and there may not be sufficient scanners at the law firm, and there may not be sufficient scanners in court either. There may not be sufficient manpower to help operate the scanners because the proceedings may involve unrepresented litigants. The second point is that 50% of law firms have not yet sign up for ICMS, and I think the major reason is that these firms have yet to procure heavy-duty scanners because of the workload involved. And after procuring the scanner, you need to have a proper server in order to provide secure and low-cost scanning service. So for small to medium-sized law firms, how can you make sure that they can get access to safe servers without making huge investments? Especially, I understand that the EBRAM is offering services for small to medium-sized law firms. But at the moment, according to registered users, there is no solution for the secure and safe storage of documents. Now, on the one hand, we are pressed by courts to adopt ICMS to go paperless. But at the same time, I think we're stuck here because we don't have a proper storage and secure storage. And I also like to refer to the point raised by Mr. Chow, the representative of the Bar Association, and that we need technical support. And how does the government come in? And of course, I learned from Law Society that training is available. But there are other matters, such as building data servers, heavy-duty scanners, a lot of hardware and software are involved. So I'd like to make this suggestion once again, that the tax breaks should be offered for law firms to procure hardware and software in adopting law tech. I'm sorry, we didn't invite the EBRAM representative to come, so perhaps somebody from the Department of Justice can take this question. Deputy Secretary for Justice, or rather JA. Thank you, Chairman. I thank Ms. Maggie Chan for her question on ICMS. As pointed out in the PowerPoint presentation, to mandate the use of ICMS in 2026, we mean to say that these mandatory arrangements will only apply to cases already covered by the ICMS system. Otherwise, it's not a mandatory use. And meanwhile, about the scanning arrangement, for law firms that have yet to sign up for ICMS, if there is a need coming from the client, then we will require documents to be scanned. Starting from the 30th of June, at the level of the High Court, you may choose to register yourself under ICMS for e-filing and e-inspection of documents, and that it can be done in one go without any scanning involved. Now, from our experience in recent years and also from user feedback, no major technical issues have been identified. But according to the feedback, we are in fact waiting for more types of cases to be included under ICMS for the extensive adoption. So that is why for those who are still submitting paper form documents, if need be, they should scan the documents. But otherwise, if the users have opted for ICMS, then they can already file the documents electronically. Deputy SJ, right, like Chairman said, we don't have EBRAM representative here, but allow me to explain what is available in the public domain. Now, we have the Hong Kong Legal Cloud Service. This is, as the title suggests, a cloud computing service. It provides a data storage service that is safe, reliable, and affordable. It's for use by our profession. And earlier, we also established a law tech fund for solicitors, barristers, arbitrators, and mediators to subscribe to the service. And starting from March 2023, we've expanded the scope of subsidy to cover solicitor trainees, pupil barristers, as well as full-time students currently reading law, or even non-full-time students. Now, this service was rolled out officially on the 1st of March 2022 for 3 years. Upon completion in February 2025, 4,362 subscribers were recorded. Now, according to our information, starting from the 1st of March 2025, EBRAM has already been allowing registration for the service by individual users. And we also plan to invite solicitor firms to subscribe the service. A bulk account discount will be offered. Details will be announced in the third quarter of this year. So this is the initiative rolled out by EBRAM, which is supported by the Department of Justice. So this is the Hong Kong Legal Cloud Services for our legal professions in Hong Kong. Now, about the other points raised, such as e-filing with the courts, then I think this has to do with the interactions between law firms and courts. Next, Ms. Carmen Kan. Thank you, Chair. My first question relates to ICMS, the question already asked by Ms. Maggie Chan. I thank the administration for clarifying the matter. Now, my original question is this. Next year, the administration will mandate the use of ICMS. So, as per the two legal representatives, you have achieved progress, and the take-up rate is now 67%. According to the subsidiary legislation, it will come into effect on the 30th of June. And from your PowerPoint presentation, apart from the items 7 to 11, I see that many types of cases will be included progressively, starting from June 8, October, December, including civil appeals, commercial litigation, construction cases, etc. So, does the timetable dovetail with the progress? Since you mandate the use of ICMS, and as the Jay just explained, there is a take-up rate of 67%. What exactly is the objective or the target rate? Now, about AI or generative AI, we've just heard the government's position. The Bar Association also welcomes this position. According to the judiciary, matters such as confidentiality, personal data privacy, and restricted access to data are not yet confirmed, and whilst we welcome the use of AI, the judiciary does not recommend the use of AI or generative AI in case analysis or the writing of judgment. So I'd like to know more about this assessment process. Is it a continuous process? Is there a dedicated department or a unit or a task force to undertake the review and assessment on generative AI? My third point is this: about the upgrade of IT infrastructure for the district court building. You are now in the procurement process. I'd like to know whether there's any update. At the security panel meeting tomorrow, as I've read from the paper, we will be discussing various matters, and that there are considerations on geopolitics, the supply of parts, maintenance and repair in the future. The administration has decided not to adopt a procurement process but to adopt direct purchase.
Judiciary Administrator, I thank Ms. Khan for her questions. Now, first, the ICMS. There are 11 kinds of cases. We will cover those cases in phases so that the legal sector and unrepresented litigants can start using the ICMS progressively. For me, I would like to see more law firms and lawyers sign up and use the ICMS. In 2026, we will mandate the use of the system for represented litigants. Publicity will continue. Training workshops will also be organized. Law firms can get in touch with us. We also offer training on how to use the ICMS now. Organizations can come to us. The system causes a little technical difficulty. Law firms simply want to wait for a case to come along before they use the system. When we mandate the system and when we start mandating the system, the usage will go up. Now, on generative AI, we keep exploring the use of AI. The Judiciary Institute arranges training for judges. Use of IT tools is part of the training, starting from 2023. We have tried using large language models for clerical tasks. As long as the work is not legal analysis, if it's just clerical tasks like drafting speeches and administrative tasks, we allow our staff and judges to use generative AI tools, but the responsibility rests with the users. People cannot pass the buck when they use AI-based tools. But our testing shows that LLMs do make mistakes in legal analysis. Say when we ask the LLM to get the gist of a legal text, we look for a summary. LLMs give us inaccurate information, and the legal reasoning remains opaque. So to ensure justice, which is our priority, we have not allowed judges to use AI tools for judgment writing. But we will keep exploring this space. We will look for a prudent way for judges to use the AI-based tools. Still, those tools need to be used in a responsible and prudent way. So the Judiciary Institute is tasked with the work. That's within the judiciary. We have a management committee. That committee is led by the Chief Justice of the CFA and the Chief Judge of the High Court. We also have other senior judges on that committee. We have people with a legal background working at the Judiciary Institute. Now, on the third question about the district court building, the funding has been approved by LegCo. We're procuring the IT systems for the new district court building. Our procurement timetable is in line with the construction timetable, and we are on track. By the end of 2026, the construction will be substantially completed, and then 12 months after, that is the end of 2027 or early 2028, the new DC court building will open, and we are proceeding with procurement around this timeline. Chairman, my question is specific. Have we borne in mind geopolitics as a factor? Some countries may decide to stop supplying certain systems all of a sudden. So the supply of the systems may be disrupted all of a sudden. Has this been assessed? We work with the government closely on this. We follow the strictest standards laid down by the government when it comes to IT systems. When we procure software, hardware, network solutions, we strictly adhere to government guidelines. We don't just make up our mind on our end. We follow the government's guidelines. Ms. Khan brought up possible risks where the supply of certain systems may be disrupted. We do consider such risks in our decisions. Thank you. Now, I wonder if any member objects to extending the meeting for 15 minutes. If there's no objection, I extend the meeting for 15 minutes. Let's be brief in your questions and answers. Mr. Dennis Low. Thank you, Chairman. On the 26th of May, the panel on public service visited Shenzhen. We had a look at the operation there. We went to a court. We were told about the use of AI-powered tools to assist with court operations. The use of AI, even in judgment writing, was already well established. On our side, the government is also making greater use of technology. We're going digital with the court's work so that we make better use of resources. But we're not going fast enough. We should go faster. Problems come up when you use AI tools. And that's because we don't have enough data in our database. We just heard about large language models. For LLMs to work, you need a large amount and a wide variety of data for the model to learn. What you have now is an LLM that has picked up the wrong information. That's why your LLM gives you unreliable information. And since LLMs matter so much, does the government have plans to commit resources to our LLMs so that we have more data in our database and legal practitioners can use the LLM? We have so many court judgments in Hong Kong. What's our progress in digitalizing our court judgments? If we fall behind in terms of going digital, then that's a problem. So who's so who are you? Where is this question going, for the DOJ or the judiciary? Now we have the Hong Kong Generative Artificial Intelligence Institute, and it's working on a local large language model. This is funded by InnoHK. And now we have the Copilot application based on generative AI. Now we are doing a trial run of this system. The Department of Justice is part of the trial. Early this year, DeepSeek entered the picture. Our model is based on DeepSeek. So this is a large language model being developed. We're doing a trial run. We would like to see wider usage of this LLM. So we're looking to expand the usage of this system as long as it's safe to do so. Local universities also have similar initiatives. Now, at the law faculty of CUHK, they signed a memorandum of cooperation with SenseTime. So they're working on joint development of a legal model to provide legal information round the clock. And then at the Polytechnic University, they have a Policy Innovation Center on the 26th of April. That center also announced a new legal model. It's version 1. Our local universities are trying to build our own legal system. We have also been looking out for technology elsewhere, such as those in the mainland. While the data available on the mainland may not work for Hong Kong, but I can see the mainland's law tech businesses take a keen interest in coming to Hong Kong. They take an interest in us even though we have a small market, and that's our major problem. But those law tech firms take an interest because they want to train their own models so that their models also knows the common law. Those firms are keen, they are willing to come here. Overseas, there are also law tech solutions suitable for our local legal sector. But the price is the major factor putting off law firms, and we also have to be mindful of security. When we go for overseas products, our access to those products may be cut off all of a sudden, and then we will be caught off guard. So we have to explore these matters with care. I'll stop here. Ms. Maggie Chan. Now, I want to approach AI in law from a macro perspective, and I want to discuss the ICMS. I know we're trying to put in place standardized formats on the ICMS, and that will lay the basis for the use of AI-based tools in the future. Now, the ICMS is not an AI tool, and it's not a form of law tech. The ICMS simply marks a start. It's important to scan documents and turn these documents into electronic files. Courts want to go paperless. For that to happen, law firms also need to go paperless. So we will need to store those electronic files. ICMS won't be mandated until next year. I get it. My point is, for law tech and AI-based tools, we need to go paperless, we need to go digital in our work. After we have the ICMS in place, we have to consider the next step. Now, we visited Shenzhen with Mr. Dennis Leung and Chairman. It took Shenzhen 5 years to go digital and go electronic with court documents. That was a painful process. It took the mainland 5 years. So for us, with the ICMS, we want to start using the ICMS starting from next year. We will need another 5 years starting from next year, so it will be 6 years from now before we can go paperless. So in the meantime, we will need a secure and reliable way to store the data. And then we can work on the format. And then we can classify the documents and analyze the documents and analyze the evidence and find out the points of contention. And then we'll get to the legal point and help the judges with judgment writing. In the end, all the tools we adopt are there to help the judges. The mainland offers speed. They're doing well. Now, adopting all these tools will mean a cheaper process for legal and dispute resolution services, and lawyers can focus on more high-end services. Now, we will need 6 years on our side before we have a more established AI system. As Mr. Dennis Jones said, but only then we will have the data. We have to move fast. Let's not drag our feet.
Now, my second point is this. I need to declare that I'm a member of the consultative group on the promotion of law tech, and from the Department of Justice paper, I see that there is a more rigorous effort being made on the promotion of law tech than ICMS. Well, I appreciate the efforts made by the judiciary, but we can't confine ourselves to just ICMS. We need to think ahead. And I understand from the DOJ's paper that they're conducting focus studies and they're also interacting with the sector. So it really deserves our appreciation. What is the most important thing is to lower costs and to enhance the efficiency of the profession, as well as aligning ourselves better with the global community. Now, I'm referring to paragraph 12 of the DOJ's paper. There'll be more resources devoted to law tech on its website, including the creation and publication of a roadmap to embark on technology adoption etc. Can you elaborate on this? Because everybody is getting ahead of us, including the mainland and other places in the world. So I thank the DOJ for their efforts, and I understand from the Deputy SJ that a roadmap at the macro level is now available. But we need a joint effort between the government and the sector, as well as the judiciary. We need to quicken our pace and enhance coordination. Don't just get fixated on ICMS. You need to think further. Right. I think the first part of Ms. Chan's comment is, in fact, a question. Jay, any response? Now, about the development of originated documents, and in fact, it's a big step forward. In the past, when we promoted paperless system, we talked about scanning documents, which are physical documents in the first place. But now when we use templates as the original document, you can just fill in the form and it will be stored on a system. Right, in the interest of time, I don't need a lengthy speech, I get the point. But indeed, as far as the court system is concerned, it's a template. But for the law firms, they still need to go through a lot of processes. I just want to explain the plight of the law firms. Now, about generative AI, to echo what the Deputy SJ said, the judiciary is now closely monitoring the development of the large language model developed by the government and how it applies to, say, legal case analysis. And that it is useful, then we are happy to let our judges and judicial officers, as well as the support staff within the judiciary, to get their hands on the LLM to assist in their operations without compromising security and reliability. I also like to chip in, like the member said, I do think that we need to quicken our pace, but that means we still need to go through things step by step. We can't miss a step, because one of the steps is to encourage adoption by the sector. In fact, there are still concerns from the sector about the necessity of adopting technology. So we need to put pressure on them for a paradigm shift in culture for the sector to adopt technology. The next step is to put technology to good use, and that means how technology can help you run the law firms. So these are steps that we need to go through, including education. And as mentioned, we're going to hold roundtable meetings within this year. We're going to hold a series of events to make the sector understand that this is something that they have to learn to use. And the next step is about choosing products available in the market. We'll explain to them the products available and what products are value for money. So that means we will tell the sector about products available in the market and how they will help you run your business in the law firm. The fourth point, or the fourth step, is about safe use of data, including addressing personal data privacy concerns, security of the system, and data security risks, ethical guidelines, etc. Guidelines will be formulated. So I just went through all the 4 steps contained in the roadmap, and we will make a joint effort with the sector in going through all these steps so that we can enter this new era of law tech development. Sorry, Chairman, just to supplement. Well, the Deputy SJ used to be one of us in the profession before he joined the government, so he has the full picture. I don't want to criticize him. I just want to say that this is indeed a mounting challenge. it's not that we are disincentivized. We just don't know how to use technology because the large language model may cause confusion. They may have hallucinations. So we do have high hopes. I feel encouraged by the Deputy SJ's remark. My last point is this. It's about law tech and AI. Technology is rapidly evolving, but we see opportunities as well as crises. We need to surmount the challenges together. Right, that wraps up the item and the discussion of this item. If there is nothing under AOB, the meeting is adjourned. Thank you.